All right, everybody, welcome. Another episode of The Update with John Reilly, Saul Klein, and myself, Tristan. We're on YouTube, so you can catch us on there. Any of these are recorded. All of them are recorded, and they'll go over there. We also have a podcast, so take a look at that. Our goal in all of these sessions is to just bring you up to date with what's happening out in the wild with NAR, all the lawsuits that are happening. Obviously, we can't cover all of them. We're trying to bring you highlights of the ones that we think are important. Obviously, what just happened literally like 30 minutes ago is the court finally passed the settlement. They said with no changes. They said everything looks good to us. And the reasoning behind that, Saul, I was hoping that they would come back and say everything's going to pass, but the buyer broker agreement, nobody has to sign that crap, right? That's what I was hoping for, but they didn't say that.
Really?
So that was my hope. But why did they just let it go through, even though the DOJ is like, no, we hate you, we're going to kill you, we're going to destroy you, it's not over? Why?
Yeah, well, so first note, and John Reilly brought this to our attention, and that is that, first of all, we've been calling this the proposed settlement, right?
Yep.
And people go out of their way to correct you. If you say the settlement, they'd come back and say the proposed
All day.
settlement, right?
Tell me that all
The
day.
proposed settlement. Well, as of today, it's no longer the proposed settlement. It's the settlement. And why that's important is the attorneys now can get paid. And so the billion-dollar bucket of money that's been collected, 410 million from NAR and then from the various other defendants, $1 billion. Now the attorneys can collect their 300 plus million dollars on this litigation. So it was important from that perspective. Also, and we said this, Tristan, with you right from the start, and that was that this Sitzer-Burnett case and the settlement was a civil action. It was civil class action antitrust, civil. And that means private parties going at one another. And then the settlement was between the private parties. Well, the Department of Justice. And then people say, but what about the Department of Justice? Well, what about the Department of Justice? Well, the Department of Justice, and they make that clear in the statement of interest that they filed 2 nights ago, and that's a whole nother story. The Department of Justice was not a party to the litigation, nor were they a party to the settlement, which means the Department of Justice, and they cover it in the statement of interest that we're going to cover, that they're not bound by any stinking settlement, right? They can come after the parties for violations of antitrust, and they're probably likely to do so. But I'll throw a caveat in there because everybody asks us.
Yeah.
Well, but Trump got elected.
Yeah.
And, Trump's DOJ had a deal with NAR, and then Biden's DOJ took over. And when that happened, the Biden DOJ went back on what the Trump DOJ had done and what they had agreed to. And so some people are kind of hanging their hat on, well, now that you got Trump in there, it'll go back to the way it was. And I'm not sure that's a safe bet.
Yeah, I would agree with you on that, since they were the ones that initiated it in the first place, right? During the Trump administration.
It started with them and then they settled, right?
Yeah. What do you think, Bill?
While the DOJ was not a party to it, the DOJ and I think their attorney was Jason Cantor, did participate, in the sessions negotiating these settlement. Now, they didn't sign off on the settlement, but they were at several of the settlement discussions. But they clearly are separate and are not a party to it. So what they're doing, the DOJ is going to continue on with their efforts in an existing lawsuit under the Sherman Antitrust Act.
Well,
So
so you know, there was a very similar case in New England, the MLS PIN.
Yep.
And the DOJ stated they filed a statement of interest there as well. And John looked it up last night. It was 33 pages. And if you read that, you knew kind of what the DOJ was pushing for. And then everybody thought in this Sitzer-Burnett settlement that the DOJ would step up. When is the DOJ going to weigh in? Oh, before the election, people thought Halloween. Well, they didn't step up. And everybody was saying they got to step up because if they don't, then it's like speak now or forever hold your peace. But they waited till Sunday night.
Yeah, I know.
Right?
I
48 hours.
sent it to you guys.
Yeah, you texted me. I'm sitting in bed. I get a text from Tristan. Right. So look, what do you guys think about this? Well, I'm half asleep, but let me look.
That's what I think about it. It's funny.
And so that if you and that statement of interest is only 5 pages. So just about every line in this tells a story.
Well, let's go through it.
And yeah, let's go through it. I think it'll be instructive, and I think it's valuable, and it'll give people some vision as to what they might be able to expect and what they need to be thinking about.
Let me pull it up right here. As I'm pulling it up, I think it's important to go through it. Here's what I think, guys. I know I'm just letting the audience know. The reason we think it's important because it shows us what the Department of Justice is looking at for the future. Like, what's their main concern here? And it wasn't addressed. I mean, it's right. Everything passed today as it was. So here's what it looks like. So Saul, I don't have mine highlighted as much as yours.
Yeah.
So you're going to have to guide me. Page 1 is just the party's easy statement of interest.
So let's look at the first paragraph in page 1. I think it's instructive. It says, if you go down about 3 lines, the United States. Now, the United States, John tells me, is not only the Department of Justice, but it's also the Federal Trade Commission. That's the United States. It's the enforcement agencies of the U.S. government. So that sounds awesome. That sounds kind of like overwhelming, doesn't it?
Yeah.
I got my friend Walt Bukowski one time was running an MLS and an association of realtors, and they were served by antitrust, and they named him specifically. He said it was the United States versus Walt Bukowski. And he kept that because he thought it was so impressive that the United States would come after him, right? So it says the United States continues to scrutinize policies and practices in the residential real estate industry that may stifle competition. It is a matter of public record that the United States has an open investigation into these practices. So right off the bat, the DOJ is warning everybody. They're saying that we're going to continue looking at what you're doing. We're submitting this statement on this, but we're going to continue looking at what you're doing. And everybody knows we are investigating the real estate industry, right? Yes. And so it's important to know that they came out 48 hours before the hearing and said, hey, everybody, first thing they say is, we're not done with you. It's public record. We're not done with you. Right, John?
Yep.
So the next paragraph, if you go down, right at the bottom says competition, and we know this, competition in real estate is critical, and home ownership is a key component of wealth of American households. So the DOJ is laying the groundwork for how important it is for there to be competition in real estate. And as we would say there's plenty of competition in real estate. We're not the Department of Justice. And you got to listen to the Department of Justice, whether you like it or not, whether you agree with it or not, right? And so the next paragraph says the proposed settlement, the second sentence, the second line, the proposed settlement does not limit the United States' ability to enforce antitrust laws. So right there on the first page, second paragraph, they're saying basically, hey, you guys can have your settlement. You can have your litigation amongst private parties, but your settlement doesn't stop us from coming after you for violations of the antitrust laws, for which we are currently investigating, right? It's not an idle threat. Including to seek greater relief for the conduct at issue here. So what they're saying is, look, you guys came up with an agreement. We now know the judge even accepted it, but the DOJ has said that they could even go beyond that, right? Seek greater relief for the conduct at issue. So it's just important to know the DOJ is still investigating. They believe that they can go after people for more than was settled here. And the tone of this whole statement of interest seems to indicate that they will, right? And they said the United States takes no position on your settlement. You guys go do what you want. We're not going to say yes. We're not going to say no. We're going to make some points about it. No, we're still investigating you.
But they have one concern, right, Saul?
And the one concern, the big thing that they're, and we joke about this, Tristan, because we thought we hope they win on this one, right? Is this written agreement. They're saying, but the proposed settlement includes a provision requiring buyers and their brokers enter written agreements before the buyer tour any home. And then the DOJ says, this provision itself raises independent concerns under the antitrust laws. So they're saying, hey, you guys are agreeing to have the buyer sign a contract. We think that might be an antitrust violation.
So can you guys, so I know why I think. I have a little Google Doc that I put reasoning behind it. Can you tell me what you think about why they think that hinders the fluidity of purchasing a home, and because they also bring up not just as it's hard for buyers to buy a home, like we're putting something to block them, but it also says it's an unfair practice for the rest of the industry on our end. Like, what are you guys seeing? What are they seeing that we may not be seeing there?
Go ahead, John.
Well, basically, they feel that requirement of a buyer agreement will stifle competition. And the competition they want more competition in the stage of the transaction, which is the negotiation between the buyer and the buyer agent. And they feel that this earlier step is going to stifle that competition. So the DOJ's main concern, of course, is to foster proper negotiations and stifle any type of thing that's competitive.
Got it. Okay, so then I want to share with you what I wrote out. You tell me what you guys think, and then Saul, we'll go back to reading it. This is what I wrote out when I read this at night on Sunday night. I haven't even looked at it again. The DOJ says this is the main problem. What I thought, it prevents buyers from even getting a no obligation showing, right, without first committing to a written agreement. And that goes back to what we talked about months ago, guys.
Right.
Barrier to market entry. The DOJ implies this creates an unnecessary barrier between buyers who want to view homes. These are their words. Their ability to freely choose and evaluate real estate services. More importantly, consumer choice restriction through forcing consumers into formal agreements. I think this is the biggest challenge before they can even begin the basic process of viewing homes. And so, their words, it limits consumers' ability to test drive different brokers or services before committing.
Well, yeah, I agree, Tristan. You're right on. And so certain people, certain business models might say, part of my business model is I'm going to take you out and show you properties. I'm not going to charge you for it.
Yeah.
Right. And this might preclude that from taking place.
Yeah, it will.
And so say, hey, my business model, I don't make any money till I close the deal, till I drag you across the finish line. I don't ask you for any obligation. That's my business model. And this kind of forestalls maybe that kind of business model. And so the DOJ says that they don't, so it has to be applied. See, that's the other thing. We know that this idea of a buyer broker agreement or even representation, does it have to be representation? Can it be non-fiduciary duty? What does it say? Does it have to be exclusive? Can it be per property? all of that's kind of, nobody defined that. And so there are ways to do this, I'm sure, that aren't violations of antitrust, but it was laid out in such a nebulous way that you got different states looking at it in different ways. You got different brokerage firms looking at it in different ways. It wasn't Zillow that introduced the Turing agreement. And so there's all this confusion around this. And so that could be part of it. But they're so strong about it, they say that first it can raise antitrust concerns, and then it says, but the parties could eliminate this. You could eliminate our concerns.
Yeah, that was my favorite part. That's why I was hoping they would.
They say you could eliminate our concerns if you just eliminate the provision. Well, if eliminating the provision eliminates the DOJ's concern, that tells you the DOJ doesn't like it.
Yeah.
Because if you get rid of it, we're okay. If you don't get rid of it, we're concerned. Or, hey, if you're going to keep it, you should disclaim that the settlement creates any immunity or defense. So if you're going to keep it, you still might be in violation of, you could be in compliance with the settlement, but you might be breaking the antitrust law. And the courts, you should tell people that just because they follow your agreement doesn't mean that we might not come after them. And when I read this, it makes me think of when you go to rent a car and they ask you if you want insurance, and you know that you're already covered because you got insurance on your car, and they say, hey, do you want insurance? And you say, oh, no, thanks. They say, would you sign here, please, that you don't want the insurance?
Yeah.
Then it makes you second guess yourself.
Right?
Right?
That's what they did. Such a good example. Exactly.
They're saying, hey, well, you better put it, we'll be okay if you put it, we think you should put it in there, right?
Yeah.
So the last line's important there, Tristan. It says, alternatively, the court could clarify that approval of the settlement affords no immunity or defense for the buyer-agent agreement provision.
Yeah.
So they're saying, we think this is a problem. We might come after you for a violation of antitrust law. Complying with this settlement doesn't get you off the hook if you're an agent, and you ought to put that in this because we want people to be on notice that we're not done yet.
That's crazy.
Yeah. So what's the next page? Joanne says, so what's next? The next page 2, they talk about the fact that the thing we all know is that the settlement removed the blanket unilateral offer of compensation from the MLS.
Yeah.
The DOJ's been after that. They like the idea that that's been taken away, but they believe there was steering, and that just taking it away might not be enough, and buyers might be forced to pay higher commissions. And if you go down to right after the No Select case, it says this practice does not benefit buyers who must foot the bill through higher purchase prices, regardless of the extent or quality of their broker services or whether they would be willing to pay for it anyway. And so we've been saying this. The MLS system did perpetuate, if you got your license today and had no experience and you happened to grab a buyer and they bought a home and it closed, you got paid just as much as somebody who had 30 years experience. And
That's
so
right.
there was no weight on, how much experience the buyer broker has. It was preset. The negotiation for the commission was all done on the list side. Buyers didn't even know they could negotiate. And they're saying, hey, you eliminated this offer of compensation. We like that, right? But we don't think you went far enough, as we'll see.
Yeah.
Yeah, this was the MLS provision which guaranteed payment, and that's the very provision that was eliminated when the practices changes came out. I think it was August 17th, right, Saul?
Yeah.
Yeah.
August 19th, I think we did it on the 17th, but yeah, it was in August.
Right.
Exactly. Now, if you go back to it, they make a point, and again, it's important to know how definitive the Department of Justice here is. They're not just fooling around. They say, under the proposed settlement, NAR would prohibit brokers from making these offers on the MLS itself. The proposed settlement, however, expressly allows offers of compensation to continue and for them to be posted publicly. It simply prohibits making these offers on the MLS. And in the MLS PIN statement of interest, they actually came out, the DOJ actually came out and said they don't think offers of compensation should be allowed to be made anywhere. So they're once again saying that. They're saying, yeah, you've said this, but you can still do it offline. Your settlement doesn't take care of that.
Yeah, and that just so everyone else understands, they're not saying we shouldn't be compensated. They should just say this should be nowhere, and the negotiation should start when we're submitting the offer. That's what they're saying, right?
Right. But the way people were interpreting it was there was language that said you can't do it in the MLS, but you can do it off MLS.
Yeah.
That off MLS is where people really got confused as to how to do it. And what the DOJ is saying, hey guys, that's where it could be an antitrust violation.
Listen, so John, agents are scrappy. What do you expect? We're like trying to figure out how to go around things all the time, right? As long as they're legal. So
yeah, well, so this is a big one, right? And everybody's been worried about this. Well, what about off the MLS? And the DOJ doesn't say don't do it, but it is a warning shot, right? They're saying, however, you can do, you're saying take it up, but however, right, expressly allows you to do it off the MLS. And we're not sure, and we know based on other writings that they're not in favor of it at all. And then if you go down to the bottom of this page, it says these key phrase. Then they're saying, look, we understand that you're a court taking care of a private contract negotiated for the parties, negotiated between parties, and your job is to just make sure for the class, it's a class action litigation, that the remedy is fair, adequate, and reasonable. And that's the standard of the court, that it be fair, adequate, and reasonable. So while you could be fair, adequate, and reasonable, that doesn't mean that you didn't break any antitrust laws.
yeah, true.
And that the Department of Justice's standard is not fair, adequate, and reasonable. It's to create competition, to allow for competition, to prevent antitrust activities, and that's more than fair, adequate, and reasonable, right? So they point that out. And again, it's interesting. It's only 5 pages long. The last time they made a statement of interest like this, it was 33 pages. Every page, they boiled it down to what they believe is important. And if you go over to page 3, about 3 lines down at the end of that sentence, it says a court cannot substitute optimal settlement terms for judgment of the litigants and their counsel. So it says, you have to be fair. You have to look at the whole class as a court, and you got to make sure that you don't deprive one party in the class over another. But when it comes to the Department of Justice, they got to look out for everybody, right?
Yeah, it's true.
And just kind of interesting the way they're so explicit about this. John, you got anything else you want? This whole other page talks about the position of the court and the position of the DOJ, and the fact that, and we pointed this out from the beginning, guys, and that is that this litigation and the settlement is a private arrangement. Right?
True.
It's all private parties.
If you look at this page 4, this is what I had highlighted, which we talked about, but they're saying in addition to all this other stuff being antitrust, right? In addition, the new provision that requires buyers and brokers to make written agreement before home tours may harm buyers and limit how brokers compete for clients, which is the outline I had in that Google Doc. It bears a close resemblance to prior restrictions among competitors that courts have found to violate the antitrust laws in other proceedings and could limit rather than enhance competition for buyers among buyer brokers. And then they cite these 2 cases, but for me, this is just telling me, guys, for the near future or later, this buyer, they're going to go after the buyer broker agreement, and it's going to still change in the future unless for some reason the Department of Justice eases off. And I don't see them easing off, especially how they showed up today in the settlement hearing. That they were like right on. They're saying, hey, nobody here is for the consumer. We're the only ones. And it didn't sound good.
You know, I think that everybody needs to recognize that what their concern is what they call the buyer agreement, and that is different from the buyer broker agency agreement. In other words, the showing agreement uses the language, all you need is a written agreement. And we see where the DOJ doesn't even like that. But most of the people are able to distinguish that from the buyer agency full agreement. Now the problem is if at the showing stage, when you don't really have the relationship with most of the buyer at that stage, and you commit to some type of monetary arrangement for paying the buyer broker, that you're going to be bound to that. At least the argument is that you're not going to be able to change that later. And now that put a lot of stress on the real estate agents. How do we come to a full buyer agency agreement when we're at a very early stage in the relationship? We need more consulting time to explain our worth.
Interesting. Yeah, I agree with you. There's a couple of questions for either of you. Did Saul say buyer broker agreements are a law in California?
January 1st. I think it's January 1st. Yes, they passed, and when we can get them a copy of that legislation. CAR said that they were going to pursue it. They did pursue it. There is now legislation in place in California requiring buyer broker agreements. Didn't we discuss this, John Reilly? It's on commercial as well, isn't it?
Yeah.
The only thing it doesn't include, I think, was what, leases?
Yeah, you're talking about the CAR contract?
The new California rule.
Second question: Do you think touring agreements will be enforced soon in California?
Well, what do you mean by enforced, right? So they're going to be required, or a written agreement is going to be required in California. Enforce is always an interesting word to me.
Who's going to enforce it?
Right, and the enforce is not the same as police.
But you know, there's a timing factor as well. Yes, you'll need a buyer agency agreement, but at what point? And there's leeway under the California approach. So they basically say, well, it's at the point in which you agree to have a client relationship. And that can be any time up to the time of presenting the offer. In other words, you don't need it at the showing stage, but you need to have the agreement as a prerequisite to making an offer.
You know, John, we should go back and review the agency disclosure law in California, because one of the things that when they passed that agency disclosure law in 1986, effective 1988, one of the issues was it was not definitive as to when you're supposed to make that disclosure and get the buyer or seller to agree to the representation. And so it was kind of ambiguous language. It was at that point in time when you've established more than a casual relationship. At that point in time when you've established more than a casual relationship, that's when you have people sign the agency disclosure in California. Now, when did most agents do it? Well, they say at that point in time when you've established more than a casual relationship, but in no case after you sign the offer, right? So the last point at which you must make an agency disclosure in California under the old was before they sign the offer. And so agents would go right up until they made the offer without getting an agency disclosure statement signed. And they would do it right at the offer time. Now, it seems to me that if you ask someone to sign a contract with you before you show them a property, you've established more than a casual relationship with them.
You have. And is that the problem with the Department of Justice right there? The casual relationship becoming a business at that point?
Well, I don't know if that's if that's the drawback or not. But one thing I know is if you go over to page 5, they say it again. So 5 pages, they've talked about this 6 times in 5 pages.
Yeah, you know what I found after reading this over a few times? I couldn't find why, at least for me, what am I missing as far as why it's so important for the Department of Justice to kick out the buyer broker agreement? There was no clarity as to why they think it goes against antitrust and why, even though, look, I've never liked it, right? As I'm talking about on the consumer side, uh, I just didn't have a clear indication because I read it and I see what they mean, but it doesn't make sense. It's like that there's more to this. I'm missing something and they're not
Well,
being clear about it.
so if you go back to page 4, after it says in the second paragraph, the new provision requires the buyers, right? It bears a close resemblance. They believe this because it bears a close
Yeah,
resemblance
I
to prior
highlighted that.
restrictions, and then they give cases. And so what we need to do is go back and review the cases, the FTC versus the Indiana Federation of
Got it.
Dentists
See
and
what they mean by
the Real
those.
Comp, which is Detroit. So I think we'll get further clarity if we
Saul,
review, huh?
you have homework, Saul.
John, go dig those things up, will you?
That's,
I usually do the homework.
that's so true.
So
Saul's
that's-
the one that sends us like 50 pages, and we're like, oh shit. Okay, let's read.
Yeah.
But,
So
but you know, I've always been trying to find out what's in the mind of the DOJ.
That's what I'm
And
trying to figure out.
what they really want is they want to have good, healthy competition for winning the buyer agency agreement. That's what they're hoping some of these barriers can be removed so that more people are dealing with the consumer, engage the consumer in the process more fully. That's what they really want to have happen.
They just want to push the buyer broker agreement further down the line then.
Yes, and not confuse it with the showing agreement. That to me is the key point.
well, I think we got to go look up these cases. They're both FTC cases, Federal Trade Commission, and the FTC is the enforcer.
Right.
Right. And so we got to see what these cases are. And I kind of remember that Real Comp case, but we should go review them because they state right here, right, that they're basing this on they're feeling on these 2 cases. They give us the cases. And so we need to go look those up.
We'll go do that. I just wanted to do 2 comments. Keith made me laugh. He said, hopefully those DOJ employees are eliminated soon enough.
Elon Musk
this is a good point. Good point. And then Cindy says maybe the DOJ needs to do real estate and they'll find out that there's plenty of competition here. Right?
Well, so that's an argument we've all made for many years.
Yep.
Right? And for the last 75 years at least, the DOJ has been after organized real estate. Now, it's also been after the technology industry and many other industries, right? So it's not just real estate. We see the Department of Justice and stepping into cases where we believe that they don't have any business. Sometimes it turns out they're right. I mean, think about this. Well, we all got something like this, right? But there was a time when there was only one phone company. And John Reilly and I remember that, right?
Yeah.
And it was felt that this monopoly was beneficial, and they broke up the phone company. And there was a time when Microsoft had Internet Explorer built into Windows, and so you got all these cases where to people on the outside it doesn't look like the DOJ knows what they're doing, but sometimes it works out, sometimes it doesn't. We all of us in the real estate industry, we believe that it's an incredibly competitive business.
Yeah, that's true.
We know that the MLS is a powerful tool. It creates a liquid market. It benefits everybody, and people ought to look at the good that goes along with this. And it seems like they never do. But they're one of the biggest pieces I took away from these 5 pages is the dislike that the DOJ has for these buyer broker agreements, which vary state to state. This is kind of interesting. Every state's got their own because real estate's state regulated. And if
Yeah.
you've got all these different states with all these different requirements and you want to get continuity state to state, guess what? Guess who has to get involved? The FTC.
Got it. Okay, so then we're getting closer. Let's see what John comes up with. Guys, I don't think it's definitely not over with the Department of Justice stepping in. I wanted to leave you with one thing, but I need your eyes on this, guys, before we go, because I think this is the next set of things that are popping up. Besides the DOJ coming after NAR in the next, I don't know, next year. Let me get there. Here, we talked about this in a different state. Now we're seeing Texas broker latest to file suit over NAR's divisive three-way agreement. What are you guys seeing with this, with the forced membership?
Well, so we have talked about this, and so we know that I look at Realtor. Realtor is a brand. Century 21 is a brand. Coldwell Banker is a brand, right? So
Yeah.
these are brands. Realtor is a brand. And I look at NAR being like the franchisor because NAR owns the brand. And then states can use that brand. And then local entities, they call them real estate exchanges and then real estate boards and then real estate associations, they too can get a charter to use that brand. But one of the rules in using that brand is that you can't just belong to one. You can't just belong to NAR.
Mm-hmm.
If you want to be an member of NAR, and I've been a member of NAR for 45 years, a long time. So I'm a proud realtor, right? You can't just be a member of NAR. You have to also be a member of your state, and you also have to be a member of your local. As a matter of fact, the way it works is you join the local, you pay your dues at the local level, the local association and pays the state and pays the national. It's called the three-way agreement. And so it gives power to the realtor brand and it works well in the industry, but people are saying, now if you look at it, it looks like it's a tying, Tying. It looks like a tying arrangement. You can't join one without the other. Now, there's also been tying with, you can't join the MLS unless you are a realtor. Well, in a number of states, California being one, you don't have to be a realtor to access the MLS because that requirement is illegal tying.
Yeah.
Now let's look at the associate. You can't just join one association. You got to join all three. That's a tying arrangement. The question is it a legal tying arrangement? And John and I have always kind of questioned how NAR and the state and locals get away with it. Not that they're trying to get away with anything, but it is tying. You're forced to join all three. And this has taken place in another state. Wasn't it in Michigan that this suit came up recently?
That was the one. That's where it started, right?
Texas.
Yep. And now Texas.
This one's Texas. The other one was Michigan.
Yeah. And so that's what it is. And so it'll be interesting to track this. But I think that what happens, at least in I've talked about this with my friends in the industry for years, and that is if there were no three-way agreement, the entity that would suffer the most would be the national and the states because people get their service locally.
Yeah, we
right?
do.
And the local collects the dues
Yep.
for the state and for the national. And so if in fact there were no agreement that you had to belong to all three, I think people would, if they wanted to be a realtor at all, they would opt for the local
100%.
as opposed to state or national. So state or national would be hurt the most, I think,
I would join the local for sure. I would join the state, but I wouldn't join the national.
Yeah, so you'd probably join the state because you get forms.
Yep.
Right, because states provide state forms and you use the forms. So state has a value proposition, local has a value proposition. I believe that NAR has a great value proposition. The things that NAR has done for us over the years.
Okay, right? That's true.
But it protects, and if you really get into it, and if real estate's your thing, and real estate's always been my thing, then I support the only real lobby there is.
Well, we need better attorneys, bro. Come on. Sending up crap attorneys to go up against, that was like such a big disappointment. It's like, we can do better. We can do better.
Yeah. So anyway, that's that case, Tristan. I think that it bears watching. You know, it's valuable to watch.
Look, well, 2 weeks from now, these are always every other week, right? So we do them live with an audience. They go into YouTube. Next, let's talk about, I think by then we'll see maybe what the DOJ is thinking. Maybe they come up with something else, right? After the fact. And maybe we see what happens with NAR. For sure, we're going to see the rest of the lawsuits play out now. So that's important. And then I think we can talk about where we think the MLSs are going as a whole, where we think NAR is going, because I think, dude, I just feel like there's so much change happening, but by the time we see it happen, shit's not going to work the same anymore for real estate agents. It's going to be very different on this side of things with MLSs, local boards, NAR. And I want to talk a lot about that. So, PJ, CCP, yeah, we covered CCP last session. I think it was CCP. We'll cover it again as it starts growing, because NAR punted it to next year. So that's definitely going to happen as well.
Mandatory submission.
Yeah, mandatory submission. Just replace CCP with mandatory submission. By the way, we're all for it here. Doesn't mean we think it's perfect, because it's not, but we think it creates a fair market for homes, right? And for people.
Yep,
in general.
for sure.
Guys, anything in closing?
Well, one comment I have is everything up until now, we've been focused on the sell side. What the DOJ has moved us towards is now a focus on the buy side. And, just like you have well done listing presentations, we have to move, the agents have to start developing their buyer listing agreements.
How to list buyers. I got a tape set if you're interested.
Cassette tape, right?
Take it.
It's 4 tapes. But the thing about this is there is litigation on the buy side.
Right.
Because those people that sold a home and bought a home, then they're going to be covered under the Sitzer-Burnett settlement. But then there's those people that bought a home but didn't sell a home, and they're not covered by this settlement. And so that's a big case that's brewing yet.
Very true. And guys, don't forget to visit the Data Advocate. That's where John, Saul, and sometimes me, they do it way more. Put in a lot of great information in the form of writing. You could read it. It goes back years. So take a look at that. Very valuable data.
Yeah, somebody asked for the full link to the DOJ, and it's in the Data Advocate.
And somebody just asked beta or VHS. It's not video. It's audio. It's audio cassette. But John, I think on the Data Advocate, we've actually got the course of instruction. I think it's about 100 pages on how to list buyers. It's pre-8-track. It's cassette.
Yeah, it's in our resources section. You're right.
In our resources section on the Data Advocate, and you know what? It still makes sense.
It does.
Read it the other day, and so I would say, Tristan, everybody have a great Thanksgiving.
Yeah. Oh, yes.
Enjoy the family.
Happy Thanksgiving, everyone. We're glad this first phase is over. Now we wait to see what's next. John, thank you so much. Saul, thank you. And everyone else, thanks for being here. We appreciate you consistently showing up, and we'll bring you great news or just news in general.
We'll find something.
Yeah.
Thank you.